It's both an honor and a pleasure to introduce our keynote speaker of the day. He reminded me that we've known each other for a couple of decades at least. I'd have to tell you that he's one of the most influential immigration lawyers since the inception of our specialty. His name is synonymous with fairness, with knowledge, and the other thing that it's consistent with is the memorandum that he signed in 1997. That memorandum has basically been the policy for administrative use of the paperwork good faith defense. Congress passed it, and it fell to our keynote speaker, Paul W. Virtue, to implement it. That was in his capacity as Executive Assistant Commissioner of the Immigration and Naturalization Service. We all followed his career. We know that he was one of the most respected of that agency's general counsel. He's currently a partner in the Washington, D.C. office of Baker & McKenzie. I want to give you your keynote, Paul W. Virtue.
Thanks, Chuck. The nice thing about an introduction like that, which was fabulous, is that I get applause before I even have to stand up. So even if you're bored and asleep by the time I finish, I will have gotten those applause right up front. So, let's see. Zolke told me that the only reason he was coming to Palo Alto was to hear my remarks. I don't see it. No, I'm just kidding. And Chuck and I have known each other for at least a couple of decades, and he's been a terrific resource and friend for me as well, even while I was with the government, to be able to talk to Chuck, get some questions, and to be able to get some really good straight answers about things that were bothering his clients or bothering immigration attorneys in general out there. So it's been a great pleasure, and it's a great pleasure for me to be out here as well. And I'd like to thank Dan Siciliano, the authors of the book, of course, in addition to Chuck, Christo, and Marcin Said, and for inviting me out here and being at the Stanford Law School. I got lost on the way here. I got lost several times on the way here, and my car is parked out there, so I might have to get a taxi cab just to get to the car, but I appreciate it. I don't have a PowerPoint presentation, and there's no reason for you to take notes. I'm not going to talk about anything as technical as what Tina was, everybody was feverishly writing down everything you said, Tina. But you don't have to do that with me. I'm going to talk a little bit about history and how we sort of got to here and where we might be going from here in the future. Just based on our past. And it is remarkable when I talk about, so when I mention some of these things about sort of the history repeating itself. I joined the Immigration Service in 1983, and that was only about 3 years after one of the most significant pieces of legislation in our time, the Refugee Act of 1980, was brand new, virtually brand new at the time I joined the agency. But having joined in 1983, I saw a lot of iterations of the Immigration Reform and Control Act before it was actually passed in 1986. But I also saw the Immigration Act of 1990. I saw and had some area of responsibility for implementation on all of these. The 86 Act, the 1990 Immigration Act, 1996, of course, which was largely an enforcement-only bill, but we had responsibility for implementing of that. So in that 10-year span, a piece of legislation that hadn't really changed from 1952 until 1986 other than the 65 Act, which I'll talk about in a moment, changed dramatically over those 10 years. So it was really an opportune time to be with the agency. It was an interesting time, and it was really fun. So, and I think it's been beneficial for me to have been through all of that. We also had, those were just the major pieces of legislation during that time period. We also had the Violent Crime Control Act, which gave us some provisions about aggravated felonies. That was the first time we saw aggravated felonies. The Anti-Terrorism and Effective Death Penalty Act, which also was enacted in 1996, but people don't really pay too much attention to it, except we had to implement it at the time. It was actually enacted before the Illegal Immigration Reform and Immigrant Responsibility Act. And the Nicaraguan and Central American Act, which was another significant piece of legislation that provided benefits that we were responsible for administering. I'm teaching an immigration law class, and I've taken a look at this issue, and except for the 1965 Act, immigration legislation invariably is enacted in an even year. And the reason for that, I think, is because immigration legislation has to percolate during the entire, almost in some of these cases, right up to the 11th hour, has to percolate during the entire congressional session, and is only enacted in the very last few hours when nobody's really paying much attention. They want to get out of town, but literally, except for the 65 Act. And I think the reason for the 65 Act being an aberration is it was dragged along by the 1964 Civil Rights Act. And that prompted the enactment of the 1965 legislation, which made some significant changes to the immigration process. Well, let's go back and talk about the statute, which was, the statute that we deal with today was enacted in 1952, the broad parameters of it. And it did contain a new offense, which was a new offense at that time, for concealing or harboring of an alien. But the agricultural employers succeeded in obtaining incorporation of a clause which stated that neither employment nor the usual and normal practices incident to employment would constitute harboring for this purpose. So that clause was known as the Texas Proviso. And the Texas Proviso basically told employers that it's okay to hire undocumented workers. There's no penalty associated with that. The onus was on the individual employees, who had to, of course, keep their heads low and stay away from the immigration authorities because they were still subject to removal. But employers, until 1986, were not subject to penalties for hiring undocumented workers. And really, the 1986 Act began with discussions dating back to the early 1970s, 1970, 72, 73. Peter Rodino, who was the chair of the House Immigration Subcommittee, as well as later became the chair of the House Judiciary Committee, had introduced legislation in 72 and 73. Neither one of those was, and actually was successful in having bills enacted that had employer sanctions provisions in them, but none of those were taken up by the Senate. And the concern was that that U.S. employers needed a ready labor supply, and also there were concerns about discrimination against Hispanics primarily, but also anyone with an accent in the United States. There were concerns about that. There were some 17 bills introduced that had employer sanctions as a component in the 75-76 Congress, another 15 in the 77 and 78 Congress. Both houses of Congress, there were bills introduced in 1977. But they never gained any traction. There was never any momentum until in 1981, there was a report of the Select Commission on Immigration and Refugees, which was chaired by Father Hesburgh, who was the president of Notre Dame. And the Select Commission came up with a number of recommendations that essentially became a part of the 1986 legislation. The commission said that the vast majority of undocumented illegal aliens were attracted by employment opportunities, and it concluded that the success of any campaign to curb illegal immigration was dependent on the introduction of new forms of economic deterrence. And that Select Commission report became the impetus for the legislation that was introduced in the early 1980s. And the Select Commission took the view that it was insufficient to simply prohibit employers from knowingly hiring undocumented workers, as had been proposed in the earlier bills, but it recommended that there has to be a means of verification by employers to verify employee eligibility to take up employment in the United States. And a system that would allow employers confidently and easily to hire those persons who may legally accept employment. And we have seen after enactment and up until today, it's anything but easy for the employers to confidently hire people who are authorized to work in the United States. And much of that has to do with some of the issues that were dealt with in considering the 1986 Act. The Select Commission report issued again in 1981 was followed by a sort of protracted era of legislation that was introduced in the early 1980s. And then there was a conspiracy, if you will, between the Democrats and the Republicans. Alan Simpson, a Republican from a vast bastion of illegal immigration in Wyoming, took up the charge, as did Ron Mazzoli from Kentucky, another big immigration state, as you can imagine. And they joined forces to introduce legislation in the 1983 and 84 Congress, for example. Their bill did include employer sanctions. It followed the Select Commission in proposing an obligation to check all new hires for employment eligibility. It provided employer sanctions, civil penalties for basic violations of hiring undocumented workers, and criminal sanctions for pattern or practice. So this was the precursor of the bill that we saw introduced and passed in 1986. The bill was actually enacted, or it was passed by both the House and the Senate in 1984, but the conference committee did succeed in agreement on the employer sanctions element of the legislation, but the provisions relating to legalization caused the conference committee to lock up, and the Congress adjourned sine die in 1984 without enacting legislation. Finally, in the 85-86 Congress, again, these things have to percolate for a couple of years. As previously, the Senate acted first in passing legislation, and then the House acted. But Simpson's bill that he had introduced in the Senate was less concerned with avoiding the discrimination that the bills in the previous Congress had as a component. And he omitted both the requirement to check all new hires and the proposed anti-discrimination rules to protect legal workers. In the House, though, the proposal for immigration reform was made by both Chairman Rodino and Ron Mazzoli. In May of 1985, they introduced the bill, and that did seek to protect against discrimination and retained a civil penalty for failure to comply with the employment verification process for all new employees hired after a certain date. It also created the Office of Special Counsel in the Justice Department as one of the components. The bill passed the House in October of '86, and in the very waning days of Congress in November of 1986, the conference committee got together and worked out a deal that led to the legislation that was signed into law by the president on November 6th of 1986. Now, Simpson referred to the approach that he and Mazzoli had taken because employer sanctions was not it was only one of the components of this legislation. He talked about a three-legged stool. Simpson talked about a three-legged stool. Leg one was improved deterrence of illegal crossings by using better technology, better training, and employer sanctions against employers. In other words, providing for a deterrent against from people coming to the United States for work. Leg two, an important component that people probably forget about, was the H-2A program, which a ready source of employment for agricultural employers in the United States. And it was also designed to ensure wage and workplace protections to avoid the earlier abuses that we had seen in the Bracero program, which dated actually back to the 1950s. And leg three was the legalization program. Under that program, people who had been in the United States unlawfully since prior to January 1st of 1982, and also certain agricultural workers could have their status regularized to permanent resident status in the United States. And pursuant to that, we legalized some 3.5 million people out of an estimated, at that time, some 6 to 7 million people who were thought to be unlawfully in the United States based on the census figures. And part of the reason for that, we suspect, is that people were very reluctant to come forward and expose themselves to immigration authorities, whether there was a free green card on the other end of it. It wasn't free, it was $85 to get the green card. But whether there was that or not, making themselves exposed to the immigration authorities kept almost as many as half of the people who were undocumented in the U.S. And the calculation was that a lot more people had been here prior to January 1st, 1982, from coming in to legalize. So that we had the 1986 Act, and of course, it's worked because we don't have any more undocumented workers in the United States today. It's wildly successful. And so I'm not even sure why we're having this conference. We don't even need to do any enforcement. But of course, we all know that is not true. We have had some problems with enforcement of the law. It's not perfect. And we've seen in terms of both priorities that the Immigration Service has given to the enforcement of the Act, as well as some of the other agencies, and the priority that Congress has given to enforcement of employer sanctions has been less than robust over this period of time. Let me just talk about that a little bit. Well, before I get to that, let me just talk about the 1996 amendments, because that there was a relatively significant change in 1986. I think you all know about what the penalties are and what the criminal penalties are, and we've talked about that a lot today. But one of the reasons, and the reason for even having a virtue memo in 1997 was during the debates on an enforcement-only bill in 1996, Sonny Bono, who's representative from California, introduced a provision which was basically a good faith defense, that if an employer acted in good faith to complete the I-9 verification process, but for technical and procedural errors, there was a defense to a paperwork violation, and also, a defense to could be raised as a defense to knowingly having hired an undocumented worker. And I actually sat through every single minute of the markup for the 1996 Act. And I have to tell a Sonny Bono story, because poor departed Sonny, he was, he's on the Republican side. He was like sort of right around in the middle of the group over there on the Republican side. And one of the days, and the markup literally went on for almost 3 weeks. in the House Judiciary Committee. Can you imagine the firepower that was in that room every single day for 3 weeks for the 1996 Act? Markup was unbelievable. But Sonny had gotten a new camera. And apparently and it was a digital camera. He'd never seen a digital camera before and didn't know how to and so during the entire markup one day, he had the box there, he had the instructions there, and he had the camera there. And he was just sitting there fooling around. He's reading the instructions, and he would, and we're all sitting in the audience, and he would pretend to be taking our picture. And he's reading the instructions and trying to figure out this camera, almost for 4 hours during a markup one day. It was unbelievable. So the fact that he was actually paying attention enough to introduce an amendment on the 1996 Act was just remarkable. But basically, that the amendment said that notwithstanding a technical or procedural failure to meet one of the requirements, an employer who makes a good faith effort to satisfy the Form I-9 verification requirements is considered to have complied with the requirements so long as they take steps within 10 business days to correct, after notice by the government, to correct any technical and procedural errors. Unless the government determines that there's been a pattern or practice, this doesn't apply to employers who have been found to have engaged in a pattern or practice of violating the Act. There's no good faith provision for missing I-9. So if the government notifies completing a missing I-9 didn't carry the defense. And so we as an agency felt the need to, based on the Bono Amendment, that we had to differentiate between substantive violations and technical and procedural violations, and essentially that's what gave rise to the so-called Virtue Memorandum of March 6, 1997. Actually, I have a question. My law firm's paying me $5 per time anybody mentions the Virtue Memorandum. And Dan was going to keep track of that today for me, so I don't know. How did I do, Dan? Is it $400? That's worth it. Dinner's on me tonight. And today, and the idea was we'd have this interim guidance and it would be followed by a regulation, but we had such difficulty, and I don't know if this is still true, Tina, or not, but in the Justice Department, but there was at the time such difficulty in getting regulations cleared by the office that was responsible for that at the Justice Department, that essentially, and as the last panel pointed out, there still are not regulations to implement that provision, and this was 1996. Here we are in 2011. We still don't have regulations. So essentially, this memorandum that we issued in March of 1997 constitutes the framework for the guidance for officers in terms of applying this standard, the so-called Sonny Bono Amendment. And I mentioned just a little bit earlier that the legislation has not been phenomenally successful. And so I just want to talk a little bit about some of the problems that commentators have pointed out in terms of, well, why isn't it? Why hasn't it been successful? And it's important to consider that. And I actually was called to testify by Zoe Lofgren's office at the House Immigration Subcommittee hearing a few years ago when there was consideration. The Senate, Kennedy had the bill in the Senate floor in 2007. The House was holding hearings. They hadn't introduced any legislation. They weren't actively, they were waiting on the Senate. And so we had a hearing that talked about lessons learned from the 1996 Act, and we also had lessons learned from the 86 Act. And so I was called to testify about this. So some of this is about what we testified in that hearing. But we've seen a steady rise in the number of, if we legalized 3.5 million, there were 6 to 7 million, then that means there was still a residual number of about 3 to 4 million people in the U.S. who were undocumented at the time. Today, estimates are anywhere from 12 to 15 million. So we can see that since the 1986 Act was enacted, we've had a continuous stream of migration, undocumented migration into the U.S., either undocumented across the border or people who have overstayed, a combination of those in terms of having gotten ourselves back up well even above the estimates that we had in 1986. Obviously, part of that is that our close proximity to Mexico, Central America, the continuing need and demand by especially agricultural employers, but all employers, for a ready labor supply continues to be a magnet for people coming into the U.S. And so the question is, why aren't we getting tougher on enforcement with respect to employer sanctions? Isn't it really the answer to all this? And I think the answer to that is no. It's not the only answer. It can't be a panacea. It's not going to get us there in terms of dealing with the undocumented population. One of the issues is who's responsible for enforcing it. There doesn't seem to be a multi-agency approach to enforcement of the employer sanctions provisions. It was the responsibility of INS, now it's the responsibility of ICE. Labor Department has a little piece that relates to violation of the labor laws. The Internal Revenue Service has a little bit of interest. Well, they have a lot of interest in the issue, but no real enforcement authority. Social Security Administration, same thing. So there's been sort of a problem in terms of a multi-agency attack on the issue. One of the other problems about it is that administrations either take it seriously or don't take it seriously. One of the issues that we dealt with early was the need to educate employers. And that was what employer sanctions was all about for at least the first 3 or 4 years of enactment after 1986. So we really didn't start issuing notices of intent to fine in large quantities until after 1991 or so, because what we were doing was issuing warnings to employers, educating employers, trying to foster an atmosphere of compliance among employers, which we still hear those words today, fostering a compliance environment from John Morton and folks who are responsible for enacting the law. So we see we haven't gotten there yet in terms of employers. And I'm sorry I missed Dan's presentation at lunch today, because in terms of tying together some of these other issues that keep general counsels of companies up at night from a compliance perspective. One of those, for example, is the deemed export provisions. We have, as a firm, have been trying to convince our clients that they need to take deemed export issues very seriously. And some of them obviously were paying attention, especially those who had significant risks in that area. But there are a lot of companies out there that do have risks that don't understand it. And so I sort of welcomed the certification for the deemed export compliance, because then I could tell my clients, you have to actually put your name on a form here, and you're going to certify that you have reviewed these regulations and that your company is in compliance with them. So it made our job actually a lot easier from that perspective in terms of convincing people. One of the other areas that we do a lot of global immigration work at Baker McKenzie, and so and we've seen the indictment and also subpoenas related to Infosys and the abuse of the B-1 program. But if we think that employers are abusing business visas for purposes of work in the United States, it is dramatically greater in other countries. And just trying to convince those clients that, when they say everybody does it in Hong Kong or whatever the example is, it's true. So it's even that much more difficult to convince them when the Foreign Corrupt Practices Act hasn't quite made its way out to the far reaches of the world. So we have it a little bit easier here, but not that easy. The sort of second concern about sanctions, which I mentioned earlier, in terms of it being an answer, is the low priority that it's been given by the agency, by the administrations, and by Congress. I felt, at least when we were there, that Congress never really funded the agency for purposes of employer sanctions. And one of the reasons that we took the approach that we did, because when I was there, we had the approach of send in a bunch of officers, close the exits, arrest all the aliens, and put them in removal proceedings. And that was sort of the approach. And then we'll deal with employer sanctions if we'll get around to I-9s later. And one of the reasons for that is that is how Congress looked at funding the agency. One of the principal sort of numerics that they looked at was removals from the United States of undocumented workers. So that's, of course, where we had our priorities. That's where we had our enforcement. And for a long time, we had about 1,200 investigators. We used to call them investigators for the entire agency, for the entire country. And they had not just employer sanctions responsibility, but they had criminal fraud responsibility. They also had criminal alien responsibility in terms of writing up people for removals. And they had employer sanctions responsibility. So the whole host of responsibilities were laid on this cadre of some 1,200 investigators. There just wasn't the workforce to be able to handle it. Now, Congress has gotten a lot better about that, has gotten a lot better about looking at the metrics and how do we measure success with respect to enforcement under U.S. immigration. And they are looking, and so, for example, they've funded the auditor positions with ICE. And ICE has been able, as a result of that, to be able to create this center in Crystal City, Virginia, for sort of coordinating the auditing of employers out there. So, that might be a scary thing from our clients' perspectives, but from the government perspective, it's a good thing because they can then coordinate. They can look at companies that are have employees across the country, and look to see whether these practices that they're finding in one location because there's a local office that's focused on one particular employer, whether there are other issues on a nationwide basis. So a lot of data mining that's going on out there as a result of that. So things really are changing, and they're also changing in terms of ICE's enforcement priorities. The Obama administration has pledged that it is getting tough on employers who hire undocumented workers, and we've seen the results of that. They're tougher than the Bush administration has been. In 2008, for example, ICE made 5,184 administrative arrests of unauthorized workers, 1,103 criminal arrests tied to worksite enforcement, and of the individuals criminally arrested, 135 were owners, managers, supervisors, or human resource employees. So those are our clients out there. And Janet Napolitano indicated a shift away from the apprehension of undocumented workers to a clear focus on employers, including detailed upfront investigations of employer compliance and the bringing of criminal prosecutions. So it's really a strategic effort on the part of ICE. In its strategic plan from last June, ICE emphasized the importance of worksite enforcement. Let me just read a little bit, excuse me, from that. The opportunity to work in the United States motivates many to seek illegal entry. Therefore, enforcing the immigration-related employment laws is a critical component of border security. To create a culture of compliance among employers, ICE will use the following two-pronged strategy: aggressive criminal and civil enforcement against those employers who knowingly violate the law, and a continued implementation of programs such as E-Verify and the Image program to help employers comply. So again, fostering an atmosphere and an environment of compliance. They went on to say that through the IE-Verify campaign, does anybody have their IE-Verify button out there? No? Not a fan. ICE intends to foster public support for the companies that use those compliance tools, so they're going to continue to push for that. And I suspect, just within the last couple of weeks, we saw the Supreme Court come down and uphold the Arizona law in the Whiting v. U.S. Chamber case. And the anticipation is that, you know, the other probably 28 states or so that don't have either legislation on the books or legislation that has been introduced will start introducing legislation to require E-Verify for all employers in the state. And my expectation is that, that both the administration and Congress are going to be prompted to act by that decision of the Supreme Court. And the concern that, you know, we're going to have 50 different priorities out there in terms of immigration enforcement. And so we really need to have one uniform federal enforcement provision. So I suspect that certainly any of the bills that we've seen introduced in the last few years have had E-Verify provisions in them, or at least electronic employment verification system, whatever they call it, requirements in those, whether they're enforcement-only bills or whether they're comprehensive immigration reform bills, have had that as a part of it. So I suspect we'll see legislation introduced fairly soon, if it hasn't been already, to require E-Verify across the board. The other sort of the weakness of the 1986 Act, and one of the reasons for that it hasn't been as successful in terms of deterring undocumented workers, is the system itself. The documents that the regulations that were amended back in 1997 reduced the number of documents down to 27. And in 2009, we had another rule that reduced it down to 26. So we have 26 documents that can still be provided in terms of identity and employment authorization. And opportunities abound out there for fraudulent documents. And none of us, and I don't think Congress or the administration want to make employers document experts. But we've all seen in our discussions with ICE that there's an expectation that companies will have in place some means of dealing with identity theft, for example, or fraudulent document fraud as part of their compliance program. And we've seen it in the best practices that we talked about on the last panel, and also in discussions. There's an expectation that companies will have in place some means of, for example, just something as simple as identifying duplicate Social Security numbers. I mean, if a company has 3 people with the same Social Security number, there's going to be an expectation, working for the same company, there's going to be an expectation on the part of ICE that the company should have figured that out. They should have there should be a process for dealing with that and a means of addressing it. Even though the 2006 regulation with respect to the no-match letters was withdrawn after significant criticism over the reliability of the E-Verify system. There still was a 1997 memorandum in effect that from the General Counsel. It was my predecessor, David Martin, at the time, who said that the no-match letter does create an obligation on the part of the employer to look further. And so even though we don't have the specific 90-day periods or 180-day periods that were set out in the ICE rule, there is still an expectation on the part of the government that an employer receives a no-match letter is going to act on that no-match letter. And as we all know, well, maybe folks don't know, but the Social Security Administration began issuing no-match letters for the fiscal year, for the tax year 2010, just this last April. Thousands of no-match letters went out in April. That's the bad news. The good news is we have time to clean that up before next April, because they're issuing these things once a year now, based on the prior tax year, and so we'll have some expectations and the government will, in terms of how companies deal with those no-match letters. So no-match is back, and I suspect here to stay. Back in 2006, I have just a few more points to make. Back in 2006, when there was a comprehensive immigration reform passed the Senate and an enforcement-only bill passed the House, Simpson and Mazzoli wrote an article for the Washington Post discussing the reasons for the failure of the 1986 legislation. And they pointed at employer sanctions in particular. And what they both said was, we saw the need for funding, and this is a quote from the article, we saw the need for funding to develop a simple, reliable, and tamper-proof system and a more secure identifier, using either cards or biometrics. Now, opponents from the right and the left savaged it as a national ID, although it was not something that had to be carried on one's person, but was to be presented only at the time of a new hire employment, or when applying for government benefits. And they went on to talk about their hope and expectation, this was September 2006, that there would be a conference and that the Senate and the House would be able to reconcile the differences between the the House's enforcement-only bill and the Senate's comprehensive immigration reform. And as we all know now, the 2006 Congress adjourned sine die without taking up that measure. In fact, the House never even appointed conferees for the 2006 legislation, so you knew it was going. We knew, of course, it was going nowhere at that time. And the most recent opportunity to have comprehensive immigration, or real opportunity for comprehensive immigration reform, came with Senator Kennedy's efforts in 2007, where he took a bill to the floor of the Senate and tried to have that enacted or passed in the Senate. But a series of cloture votes, the bill was actually pulled from the floor a few times and then reintroduced on the floor of the Senate, failed on cloture votes. And you just can't get anywhere in the Senate unless you can get you can muster the 60 votes necessary for a cloture vote. And as we've seen even more recently, Congress hasn't even been able to, the DREAM Act, that of course, there is broad bipartisan support, at least in theory, for the DREAM Act to assist kids who were brought here at a young age and have gone to high school here and have promising futures and are educated in the United States, and that can't even pass a cloture vote. In fact, it's used now as a bellwether to see what Congress might do on comprehensive immigration reform, and even the DREAM Act can't get by a cloture vote. So. It's a very difficult time. When I'm trying to predict, when somebody asks me about predicting legislation, I say, well, first of all, it's never going to happen in an odd year, so forget about 2011, because it's always happened in an even year. And I don't know. Comprehensive immigration legislation has been passed in presidential election years. It's not unprecedented, and so we might have something in the waning days of 2012. But I'm afraid to think what it might look like, and so we can continue to press that effort. Most of the components of comprehensive immigration reform include some kind of a program for an earned legalization. I didn't say amnesty. I never used the word amnesty. There's a camera back there. I'd never said amnesty. No, it's an earned legalization program. And of course, a number of measures on the enforcement side, including a requirement that employers use the E-Verify program. Let me see. Just trying to figure out whether I have any more particular. That's about it. I think I've taken us from 1983 when I started up to. And sometimes even before I started, up to the present time. And you know, I think we just have to be hopeful in terms of immigration reform. It's never going to happen unless we get behind it. And those of us who are proponents of some comprehensive reform, so we can't let down. But just in terms of the current composition of Congress, you know, it's a very difficult thing to even think about or imagine today or even in 2012. So I have left some time for questions, and as Dan had asked me to. So if anybody has any questions, I'm happy to try to answer them. I planted some questions in the audience, so somebody has to. No, hey, Wendy.
So if you have the magic wand and you could just get Congress to do your bidding, how would you fix it?
Wow.
Have to make you.
Oh yeah, yeah.
The question was, if you had a magic wand and you could get Congress to do your bidding, how would you fix it?
Well, you know, I think Simpson and Mazzoli said it in this 2006 article. They said, you know, how could we have been such a failure if the Senate bill that just passed was, you know, used the same blueprint that we had in 1986? And so they said, you know, those are the components, really. But I think in addition to some kind of an earned legalization program, some provision, the DREAM Act provisions for students, and meaningful opportunities for employers both in agriculture and in the unskilled worker area to have a program that actually works in terms of guest workers and provides assurances with respect to wages and working conditions. Those all have to be components of the answer to the problem. But I think from the enforcement side, it also has to include a priority given to some of these things like employer sanctions and border enforcement. From the Hill, it's going to cost money. It will. There's no question about it. And we're in a tight budget situation, obviously, as well. So it's not going to be cheap to fix it. So I think if asked, I would say that get out your pocketbook is one of the ways to do it. And that might mean cutting in other areas.
Questions? I have a couple. Okay. Okay.
Hey, Dan, but don't be one of those guys who keeps everybody until 6:30.
No, not at all. Well, so
no, I'm just kidding.
No, absolutely. So this is a complicated question. I don't think it asks you to divulge anything that can't be public, but can you describe how the
I'm not with the government anymore,
That's
so
true.
I can say basically anything.
Well, so the question is about the government-private interface.
Actually, I keep looking at Tina to see if she's frowning or not. And then
or if she writes something
yeah,
down,
exactly.
right? Yeah. So the question is this kind of private-public interface. Obviously, AILA functions as a really important source for the agencies to garner information, get feedback. But you mentioned, for example, you know, talking to Chuck Miller when you were working in the government and you got feedback about what his clients were experiencing. Do you think the ecosystem of the feedback loops to the government have changed? Have they gotten better? Have they gotten worse? Do you have any ideas about how to improve that feedback loop? I mean, you've been on both sides, and I have a sense that it isn't working as well as it should. Maybe that's just the way it has to be, but I wonder if there's any insight you have about making that work better, in part because we've got a lot of players in the room who are part of that in a serious way.
Sure. Well, talking to Chuck and others in an informal way was one way to do that, but it certainly wasn't the only way. I mean, we had, and speaking of AILA, for AILA members in here, the liaison committees can be a very effective way of providing feedback to the government. And we had a general counsel's liaison committee of AILA when I was deputy general counsel, when I was executive associate commissioner, we had one for programs, and when I was general counsel, we had one, which was very important, especially to me at that time, because we had the responsibility for implementing the 1996 Act, and I think we had over 100 regulatory actions to take, and just, I can't even tell you how many hundreds of memos that went out providing interim guidance to, like the Virtue memo, providing interim guidance, and all of that was done with some input from AILA. One of the areas that we just really wrestled with mightily was the exclusion ground, the 3- and 10-year bars, and how to make sense of those, and how to sort of limit the difficult circumstances in which that law placed people. Remember, when it was enacted, we had 245I was still around. It sunsetted and then was reemerged in 2000 for up until 2001. But it was still critically important because we knew 245I was going to go away, and people who would otherwise qualify for visas were going to get stranded because they couldn't adjust, they couldn't leave to go get a visa. And so I think we worked very closely with especially the General Counsel Liaison Committee of AILA to get feedback on that and to try to make some sense of it and put out some, reasonable guidance. Not regs, because we don't do, we didn't do regs, but some guidance on that provision. So, I think AILA and other organizations as well. AILA, but the second part of your question was, how do we think that seems to be working better, or worse, or not at all now? And I think the concern I have is what I'd like to see the government do is put out for comment some specific proposals and get some feedback on them, whether that be in a regulatory process or whether it simply be published in the Federal Register and entertain it at a town meeting kind of thing. But I think the notion of for example, USCIS putting out a notice saying, sort of, for lack of a better word, how do you think we're doing? What do you have any guidance? Do you have any comments on regulations or guidance? Is just too broad. It doesn't get the job done, and it doesn't focus people enough on the issues. So I guess if I have a criticism of how things are being done now, it would be that the dialogue really needs to be focused in on some specific concrete proposals in order to really to be able to have the feedback be implemented in a reasonable way. Thank you.